The term felony, in some common law countries, means a serious crime. The word originates from English common law, where felonies were originally crimes that involved confiscation of a convicted person's land and goods. Other crimes were called misdemeanors. Many common law countries have now abolished the felony-misdemeanor distinction and replaced it with other distinctions, such as between indictable offenses and summary offenses. A felony is generally considered a crime of high seriousness, while a misdemeanor is not. A person convicted in a court of law of a felony crime is known as a felon or convict. In the United States, where the felony-misdemeanor distinction is still widely applied, the federal government defines a felony as a crime punishable by death or imprisonment in excess of 1 year. If punishable by exactly 1 year or less, it is classified as a misdemeanor. Note that the actual prison sentence handed out has no effect on this. The decision is based on the maximum sentence possible under law. For example, if a person is sentenced to 6 months, but the charge can be up to 2 years, it counts as a felony, in spite of the actual time served being well under a year. The individual states may differ in this definition, using other categories as seriousness or context. Similar to felonies in some civil law countries are delicts, whereas in others crimes and delicts, and still in others, crimes and delicts are synonymous, as opposed to contraventions. Overview. Classification by subject matter. Felonies include but are not limited to the following: murder, aggravated assault and/or battery, manslaughter, animal cruelty, vehicular homicide, arson, burglary, tax evasion, various forms of fraud, the manufacture, sale, distribution, or possession with intent to distribute of certain types and/or quantities of illegal drugs. In some states, the simple possession of certain types of illegal drugs, usually in more than a certain quantity but regardless of quantity for some drugs in some jurisdictions. Grand larceny or grand theft, i.e., larceny or theft above a certain statutorily established value or quantity of goods. Vandalism on federal property. Treason, kidnapping, obstruction of justice, perjury, check fraud, copyright infringement, child pornography, mail and wire fraud, violating parole, probation, or recognizance bond, threatening an official. Broadly, felonies can be characterized as either violent or non-violent. Violent offenses usually contain some element of force or a threat of force against a person. Some jurisdictions classify as violent certain property crimes involving a strong likelihood of psychological trauma to the property owner. For example, Virginia treats both common law burglary and statutory burglary as felonies. Some offenses, though similar in nature, may be felonies or misdemeanors depending on the circumstances. For example, the illegal manufacture, distribution or possession of controlled substances may be a felony, although possession of small amounts may be only a misdemeanor. Possession of a deadly weapon may be generally legal, but carrying the same weapon into a restricted area such as a school may be viewed as a serious offense, regardless of whether there is intent to use the weapon. Additionally, driving while intoxicated in some states may be a misdemeanor if a first offense, but a felony on subsequent offenses. The common law divided participants in a felony into 4 basic categories. First-degree principals, those who actually committed the crime in question. Second-degree principals, aiders and abettors present at the scene of the crime. Accessories before the fact, aiders and abettors who helped the principal before the basic criminal event took place, and accessories after the fact, persons who helped the principal after the basic criminal event took place. In the course of the 20th century, however, American jurisdictions eliminated the distinction among the first 3 categories. Gonzalez v. Duenas-Alvarez, 549 U.S. 183. Classification by seriousness. A felony may be punishable with imprisonment for 2 or more years or death in the case of the most serious felonies. such as murder. Indeed, at common law, when the British and American legal systems divorced in 1776, felonies were crimes punishable by either death or forfeiture of property. All felonies remain a serious crime, but concerns of proportionality have in modern times prompted legislatures to require or permit the imposition of less serious punishments, ranging from lesser terms of imprisonment to the substitution of a jail sentence or even the suspension of all incarceration contingent upon a defendant's successful completion of probation. Standards for measurement of an offence's seriousness include attempts to quantitatively estimate and compare the effects of a crime upon its specific victims or upon society generally. In some states, all or most felonies are placed into one of various classes according to their seriousness and the potential punishment upon conviction. The number of classifications and the corresponding crimes vary by state and are determined by the legislature. Usually, the legislature also determines the maximum punishment allowable for each felony class. Doing so avoids the necessity of defining specific sentences for every possible crime. For example, Virginia classifies most felonies by number, ranging from Class 6 through Class 2 up to Class 1. Some felonies remain outside the classification system. New York State classifies felonies by letter, with some classes divided into subclasses by Roman numeral. Classes range from Class E through Classes D, C, B, and A2 up to Class AI. Massachusetts classifies felony as an offense that carries any prison time. England and Wales. History. Sir William Blackstone wrote that felony comprises every species of crime. The consideration for which a man gives up his fief. Blackstone refutes the misconception that felony simply means an offense punishable by death, by demonstrating that not every felony is capital, and not every capital offense is a felony. However, he concedes that the idea of felony is indeed so generally connected with that of capital punishment, that we find it hard to separate them, and to this usage the interpretations of the law do now conform. The death penalty for felony could be avoided by pleading benefit of clergy, which gradually evolved to exempt everybody from that punishment for a first offense, except for high treason and offences expressly excluded by statute. During the 19th century, criminal law reform incrementally reduced the number of capital offences to 5, and forfeiture for felony was abolished by the Forfeiture Act 1870. Consequently, the distinction between felony and misdemeanor became increasingly arbitrary. The surviving differences consisted of different rules of evidence and procedure, and the Law Commission recommended that felonies be abolished altogether. This was done by the Criminal Law Act 1967, which made all felonies misdemeanors, and introduced a new system of classifying crimes as either arrestable and non-arrestable offences. Arrestable offences were abolished in 2006, and today crimes are classified as indictable or summary offences. Procedure. The Trials for Felony Act 1836 allowed persons indicted for felonies to be represented by counsel or attorney. Terminology. A person prosecuted for felony was called a prisoner. Ireland. In the law of the Republic of Ireland, the distinction between felony and misdemeanor was abolished by Section 3 of the Criminal Law Act, 1997, such that the law previously applied to misdemeanors was extended to all offences. Minister Joan Burton, introducing the bill in the Shannon, said, "The distinction has been eroded over many years and in today's conditions has no real relevance. Today, for example, serious offences such as fraudulent conversion and obtaining property by false pretenses are classified as misdemeanors, whereas a relatively trivial offence such as stealing a bar of chocolate is a felony." The 1997 Act modeled on the English Criminal Law Act 1967, introduced the category of arrestable offence for those with penalties of 5 years imprisonment or greater. The 1937 Constitution declares that the parliamentary privilege, which protects Oireachtas members from arrest travelling to or from the legislature, does not apply to treason, felony, and breach of the peace. The 1996 Constitutional Review Group recommended replacing felony with serious criminal offence. United States. The reform of harsh felony laws that had originated in Great Britain was deemed one of the first fruits of liberty after the United States became independent. In many parts of the United States, a felon can face long-term legal consequences persisting after the end of their imprisonment. The status and designation as a felon is considered permanent, and is not extinguished upon sentence completion even if parole, probation or early release was given. The status can be cleared only by a successful appeal or executive clemency. However, felons may apply for restoration of some rights after a certain period of time has passed. The consequences felons face in most states include disenfranchisement, exclusion from obtaining certain licenses, such as a visa, or professional licenses required to legally operate, exclusion from purchase and possession of firearms, ammunition, and body armor, ineligibility to serve on a jury, ineligibility for government assistance or welfare, including being barred from federally funded housing, deportation. Additionally, many job applications and rental applications ask about felony history, and answering dishonestly on them can be grounds for rejecting the application, or termination if the lie is discovered after hire. This is because most bonding companies do not issue bonds to felons, which effectively bars them from certain jobs. Additionally, most landlords do not rent to felons due to the risk of legal liability if the renter commits another crime. It is legal to discriminate against felons in hiring decisions as well as the decision to rent housing to a person. So felons can face barriers to finding both jobs and housing. A common term of parole is to avoid associating with other felons. In some neighborhoods with high rates of felony conviction, this creates a situation where many felons live with a constant threat of being arrested for violating parole. Many banks refuse service to felons, and some states consider a felony conviction grounds for an uncontested divorce. In some states, restoration of those rights depends on repayment of various fees associated with the felon's arrest, processing, and prison stay, such as restitution to victims, or outstanding fines. However, the only way a felon can avoid being charged with a federal felony of possessing a firearm is to receive a full pardon, or restoration of all rights. Expungement for state law convictions. Expungement is determined by the law of the state. Many states do not allow expungement, regardless of the offense, though felons can seek pardons and clemency, including restoration of rights. Federal law does not have any provisions for persons convicted of federal felonies in a federal United States District Court to apply to have their record expunged, while the pending Second Chance Act would change this if enacted. At present, the only relief that an individual prosecuted in federal court may receive is a presidential pardon, which does not expunge the conviction, but rather grants relief from the civil disabilities that stem from it. Germany. Felonies are defined as a crime that is punishable with a minimum of 1 year imprisonment. Misdemeanors are all other crimes punishable by imprisonment of less than 1 year or by fine. However, in some cases a severe version misdemeanor may be punished with imprisonment of more than 1 year, yet the crime itself remains considered a misdemeanor. Same applies for a milder version of a felony that is punishable with imprisonment less than a year. A plea bargain is not applicable for felony crimes at all.